for any case in the court of law. Pleading is a very essential concept in any legal jurisprudence. Nevertheless, issues are the crux of the matter. To throw light on this topic, I would like to give a warm welcome to our esteemed dignitary, Hon'ble Justice N.Kumar. Welcome, sir, and the floor is yours.
Good afternoon to all of you. Yesterday, we discussed at length what a lawyer should do when he decides to file a suit. He must choose the court. First, he must know, though it is a civil suit, there is no express or implied bar for maintaining the suit in a civil court. Then he must find out which is the court which is competent to try the suit. So once this is clear, the stage for initiating a suit in a civil court is clear. Every suit shall be instituted by the presentation of a plaint. So therefore, the initiation of a suit is by presentation of plaint. So for you to present a plaint, first you must draft a plaint. So in civil law, this drafting of a plaint, drafting of a written statement is of utmost importance. It is like a foundation for a magnificent building to be constructed. If the foundation is strong, then you can expect a wonderful building thereon. If the foundation is weak, then your case may collapse. So therefore, Civil Procedure Code minutely sets out how a pleading should be. Before I take you to the particulars of the pleadings as set out in Order 6 of the Civil Procedure Code, let me remind the youngsters, if there is one reason for delay in disposal of cases is not following the rules prescribed in Order 6 insofar as drafting of pleadings is concerned. Probably it is born out of fear, or probably it is born out of the fact that what others would think about a pleading which is short and precise. The way today the pleadings are filed in civil courts, and in particular the way the pleadings are filed in commercial courts and arbitration proceedings, let me tell you, it is just opposed to the pleadings as set out in the Civil Procedure Code. If you are able to follow the rules, if you have confidence in yourself, if you have the courage to set out the pleadings in the manner specified in Civil Procedure Code, take it from me, a litigation will come to an end at the earliest. When a person goes to court, he is going before a judge. He has to tell the judge what his grievance is, what his case is, what is his right, what is that right that is infringed, and what is the relief he wants. If he is not able to specifically state what his grievance is and make the judge understand, how can he expect any results? If what can be said in 1 page, if it is said in 10 pages, take it from me, that is the first stage for delay in disposal of cases. All of us are human beings, we have our own limitations. Even a judge wants to readily eager to do justice, but he must understand the point. If the idea of pleading is to confuse the judge, confuse everybody, the person who has put in such a drafting has to thank himself. He will be doing a greatest injustice. to the cause. Now, in this background, let me see what CPC says about pleadings. First of all, we have to find out what are pleadings as defined in the CPC. It is defined. Pleading shall mean plain or written statement. It ends there. Pleading shall mean plain or written statement. There is no provision for filing a reply or a rejoinder. Reply by the plaintiff to the written statement and a rejoinder to that reply by the defendant. Where do you get all this? Especially on the arbitration side, it is taken for granted. Higher you go up, it is taken for granted. In writ petition, it is taken for granted. Where do you get all this? That's why I said, if you have respect for the law, if you want to follow strictly the rules of law, please stick to it. Because you are not sticking to it, and everybody is free to do what he wants, and it is also not curtailed but encouraged by the courts, today we are in a total mess. Please be clear in your mind. Pleading does not include a reply. Pleading does not include a rejoinder. Pleading means, shall mean only the plain or written statement. You have come to court. Please put in your case in a precise manner so that the other side understands it, so that the court understands it. Other side replies to it, then proceed with the trial. Now, it did not stop there. Having said that, it also says what the pleading should contain. Order 6 Rule 2 specifically says, pleading to state material facts and not evidence. What more do you want? So beautifully explained. There are stages. You plead. Give an opportunity to the other side. Let us see what they admit, what they don't admit. If they don't admit something and that is required, then the question of evidence. Otherwise, no recitative or an admit. If you admit something, no evidence need be produced. So therefore, a provision says, every pleading shall contain, uncontained, please see the words, contain, uncontained, only a statement in a concise form of the material facts, on which the party pleading relies for his claim or defense, as the case may be. It did not stop there, but not the evidence by which they are to be proved. Today you look into the pleadings, put in any court. Sometimes we have to struggle to find out what is the case, but it runs to 25 pages, 30 pages. If a lawyer were to say, look, I put in and I applied with 2 or 3 pages and the client will not pay me the requisite fee, only when you put in 20 to 25 pages, I will get my fee, I have no answer. If that is the way you want to practice, of course, you are free to do it. But today, take it for granted that the plea. Plea is there, evidence is there, arguments is there, contents of the documents are extracted, statutory provisions are extracted, judgments of the Supreme Court are extracted. And therefore it is bulky. What the judge should do? The moment it is bulky, there is a resistance to looking to it. This is also a human being. If you can say what your case is in few words, I can do something for you. If you start telling me stories, Ramayana, Mahabharatas, then there is no end. That's why the litigation is taking so much time. And if you think that saying it Ramayana and Mahabharata, putting in 30, 40 pages of wonderful Shakespearean language, I'm sorry, you may have a very good language, beautiful language, but it is nothing to do with law. What you should say is material facts in a precise, concise manner so that the judge understands, so the opposite side understands, and then they put in the defense and we can proceed further. Therefore, I am of the firm view. In fact, when I started the practice, I have seen the plain should be written, was written on the stamp paper, 2 or 3 pages. Wonderful. That means we have a control over the language, marshalling of facts. You know what to say, what not to say. And when you say it, you should say it in a precise manner, in a concise manner, so that judge understands the case, lawyer understands the case, and it will be just, today you are pleading, the whole object of pleading is to confuse everybody, including yourself. And therefore, nobody knows what to do. Spiral bird and document, judgments, not only you are producing it, you are also extending. That type of pleading is totally opposed to Order 6, Rule 2. See the way in which it is drafted in 1908, they did not stop there. They have said what it requires. Every pleading shall, when necessary, be divided into paragraphs, numbered consecutively, each allegation being, so far as is convenient, contained in a separate paragraph. Why? It may be 4, it may be 5 points. For each point, you make one paragraph. When I read it, it gets into my head. When you read it, it also gets into your head. You need not read it again. If it is arranged in a particular manner and numbered consecutively, you will be very clear in the plain in para 2, this is what I have said, in para 3 I have said it, para 4 I have said it, at the end. Today it runs to 40 pages, 100 paragraphs, and each paragraph is 2 pages. There's no end to this. Not only that, to avoid any confusion, it further says, dates, sums, numbers shall be expressed in a pleading in figures as well as in words. So precisely the law says what they expect in a pleading. Now please tell me, if this is the law, if you have respect for the law, what is it that you people are doing today? And when you don't respect the law, why are you blaming CPC for that? Why are you blaming CPC? In the end of the day, when you plead your case, what is the object? The object and purpose of pleading is to enable the adversary party to know the case it has to beat. That's all. Provisions relating to pleadings are meant to give each side intimation of the case of the other so that it may be met. To enable the court to determine what is the real cause which litigation on particular cause of action state. The moment the pleadings are read, court must make up its mind. These pleadings are meant to ensure that the litigants come to trial with all issues clearly defined and to prevent cases being expanded or grounds being shifted during trial. To ensure that each side is fully alive to the question that they are likely to be raised or considered so that they may have an opportunity of placing the relevant evidence appropriate to the issues before the court for its consideration. In order to have a fair trial, it is imperative that the party should state the essential material facts so that other party may not be taken by surprise. So there should not be any surprise. It is not a hide and seek game. Whatever you want to say, say it so that the other man knows it. Let us see what he says. To the extent he accepts it, no problem. Where he denies, that's the point to be controversy, and that should be gone. Now, certain unwritten rules have developed over the years. What is that? The relief should be founded on the pleadings made by the parties. In the end of the day, you plead all these things, show you are right, now show that it is infringed, and you say this is the relief I want. It is also equally well settled. You plead something and you don't adduce evidence, the pleading is of no use. Any amount of evidence without a plea is of no use. Similarly, any amount of evidence without a plea is also of no use. There should be a plea. If the plea is denied, in support of the plea, you have to need evidence. And if you plead 20 pages, where is it? And is it really required? So you must be able to say what your legal right in a short manner. Maybe it's little introductory things, come to the point, some references, and then leave it to the court, leave it to the other side to answer it, and then have a decision. Sometimes it so happens, in your anxiety to plead so many things, you are not pleaded what is to be pleaded. But the other side understands. Court understands an issue is framed. And at the time of argument, lengthy arguments are just saying there is no plea at all. Well, if there is no plea, why did you answer them? Why did you get the issues framed? Why did you adduce evidence on that plea? Therefore, in that context, though strictly speaking, the plea may not be strictly in conformity with Order 6, Rule 2, courts have held this is not a chess game. We are not here for fun. You said something, he understood the other side. Issue is framed. Both of you have adduced evidence. Evidence is before me. I have understood it. I will decide the case. I cannot reject a claim on the ground that pleading is not properly made. Therefore, it is said it should receive a liberal construction. It should not be too technical. For all these procedures are handmade of justice. In the end of the day, justice should suffer. But to have some continuity, consistency, these rules are prescribed. It's a rule of the game. Everybody should follow it. And that's the object. That's all. Beyond that, you cannot put these rules as mandatory. And if that is not done, the court can't do it. Court can't go into it. Court has no jurisdiction to it. The courts will not encourage such thing, because if they encourage it, then it should be a case of denial of justice to a litigant public who has a valuable right. Therefore, whenever you are pleading, for example, a case for declaration of title, so you must say how you have acquired title, or you must say how the person who is selling the property to you has acquired title. Because if he doesn't have good title, you don't get title. So to examine that, probably that is required. And that's all. You cannot go on saying history, geography, and everything in pleading, and that doesn't strengthen your case. On the contrary, it comes in the way of speedy disposal of. Now, the CPC did not stop here. Probably this was the problem then also. What they did was, there's an appendix to the CPC. Appendix A contains the forms of pleadings. Every type of suit, you have a format. The forms in Appendix A, when applicable, and where they are not applicable, forms of the like character as nearly as may be for all pleadings. This is what Order 6, Rule 3 says. In fact, in a suit for specific performance, that forum says there should be an allegation that the plaintiff was ready and willing to perform as part of the contract. In one of the cases, that plea was not there. Matter went up to Supreme Court. Supreme Court dismissed the suit on the ground this words ready and willingness is not there. So that was the importance given to this format, and they said it is mandatory. Well, there are several interpretations. Subsequently, Supreme Court found if you deal with these forums in such a forum, justice would be suffering. Then that judgment was diluted, and they said, even if those very words are not used, but the words used in the pleading give the same meaning, then that is sufficient to go on with the case. So therefore, this has given a lot of trouble to the lawyers and judges, and you have judgments. But what I would suggest is, please understand what you mean by a pleading. You are putting forth your case before the court, and your complaint is against the opposite party. So the complainant should know what your case is, so that he can have his say. And at the end of the day, the court can look into both versions and decide what the case is. If you are not able to make this suit so simple, and if you complicate it, and you take pride in writing 40 pages, 50 pages, and then in the written statement, 40 pages denial and 40 pages defendant's case, and then a rejoinder, a reply, it will be 150 pages pleadings. Then don't expect speedy disposal. If you want speedy disposal, you must respect the law. You must keep your pleadings as minimum as possible without sacrificing the substance. Now, there are cases where particulars would be required. It cannot be very precise. But then the law makes a provision. In all cases in which the party pleading relies on any misrepresentation, fraud, breach of trust, willful default, or undue influence, and in all other cases in which particulars may be necessary, beyond such as are exemplified in the forms aforesaid, that is in Appendix A, particulars with dates and items, if necessary, shall be stated in the pleading. This should be sufficient. If you say the sale deed is obtained by fraud, that is not sufficient. You should give particulars. Who played the fraud? When it was played? What is the fraud played? Similarly, breach of trust, misrepresentation, particulars are required. Without that particular, the other man will not be able to understand what you are saying. Merely saying fraud, misrepresentation doesn't take you too far. So in a case, in the plaintiff, if you are alleging something which falls under this category, mere using those words is not sufficient. You must give some particulars which you can develop in the form of evidence later so that the parties could beat it effectively. In fact, there is a provision in the Civil Procedure Code, Order 6, Rule 5. When these particulars are not given, an application is to be filed calling for better particulars. For that, an application, this calling for better application was filed by a defendant without filing the written statement. Without particulars, I can't file my statement. Then objection, then to hear, then an order, then order allowing or rejecting it, a revision to the High Court, state proceeding state. This is how the matter was delayed. In 1989 amendment, the Parliament thought we'll put an end to this, and therefore they deleted Order 6, Rule 5. That is the danger. Then when you plead, there cannot be a common set of facts. Cases vary. And therefore they have said, if a condition precedent has to be performed before another act complained of, then you have to state so that the other side understands better. So therefore, so minutely, the Civil Procedure Code provides for it. And let me tell you, you have any number of judgments contrary to this provision. When you have come to court with a particular case. In India, even today, lawyers are not well equipped, clients are not well equipped. Sometimes it so happens when you are rushing to the court, you may not be able to state everything what it should be stated. Sometimes you state something against your interest. Sometimes you say something which afterwards you will find out that is not the right thing, you have to go in a different thing. The Civil Procedure Code has taken care of all these things. Therefore, you have a provision called amendment of plaint. Now you have any number of judgments we say, if by way of an amendment you want to change your case, change the cause of action, it is not maintainable. If there is an admission and you want to withdraw it, it is not permissible. You have any number of judgments. You please see a provision under Order 6, Rule 7. It speaks about departure. You have already pleaded a case. You want to depart. Is it permissible? No pleading shall, except by way of amendment, raise any new ground of claim, or contain any allegation of fact inconsistent with the previous pleadings of the party pleading the same. Specific provision. All that it says is, if you want to retrace your step, if you want to depart, if you want to say something inconsistent with what we have already said, You can do it only by amendment. Without amendment, you can't. When the application file amendment, it is dismissed on these grounds. Please look into this provision. Law provides for it. Sometimes it so happens, I make some admission, it's not correct. I should have an opportunity to withdraw. In the end of the day, the court will find out whether it's bona fide or not. I have said something, and then afterwards I want to say something, it's inconsistent. You cannot throw me out. That's a matter for trial. That's a matter of evidence. Though the law provides expressly, if you want to depart, do it by way of an amendment. Amendment application dismissed day in and day out in courts. Anyhow, therefore it is necessary both the lawyer and the judge should know the law is. And it is all required in the end to do justice. You cannot look at everything with a colored glass. Then they have also said, if a suit is based on contract, a mere denial of the same by the opposite party shall be construed only as a denial in fact of the express contract alleged or the matters of fact from which the same may be implied, and not as a denial of the legality or sufficiency in law of such contract. A contract is pleaded, you deny the contract. Once the contract is proved, the contract is proved. You have a right and also say, refer to the content and say, this is not correct, that is not correct. If you have not done it, if you have simply said there is no contract, the moment you prove the contract, the contents of the contract are completely proved. And that's what the law says. And then when you are relying on a document, I have seen Bombay practice. The plaintiff has issued a legal notice to the defendant as under, entire legal notice is taken. The defendant has sent a reply, entire reply is there. And the correspondence are there, it is there. Therefore, the pleadings become 60 pages. CPC, which is applicable throughout the country, says, whenever the contents of any document or material, you are bare saying a letter was sent is sufficient. But sometimes it so happens, something very important, 2 lines, 3 lines are there. Or your understanding is, this is the substance of that letter. Then it says, it shall be sufficient in any pleading to state the effect thereof as briefly as possible, without setting out the whole or a part thereof, unless the precise words of the document or any part thereof. He has sent a reply admitting the claim. Fine. He has sent a reply that so and so admitting the claim. If there is any specific word, you extract. That's because entire case may revolve around that. Similarly, when malice, knowledge, etc. are alleged, probably you have to give little particulars. So therefore, pleading is an art. It is not mere writing something. It is not something you vomit. You know so many things. Pleading is an art, and you are a lawyer. And when you plead something, you must also know the law. When you plead something, it should be backed up by the legal position. Therefore, it can't be simply, come on, take down and dictate. It will not take that. That's how it is done, but it's not so easy. In earlier days, plains used to be drafted in handwriting 10 times. Every word used to be counted. That's the beauty of the trial work, and that's the beauty of drafting a plain. And now there are certain presumptions of law. It is not necessary for you to plead it. Presumption of law, court will draw it. Don't add one para and say you presume. The court should presume this because the section says so. No. This is one aspect of pleading. Now, sometimes pleadings, that forum is used, that platform is used to defame the other person free of cost, create problem. Now today, you say something and put it into the court, newspaper publishes, and people who read it gets an impression that something is happening in the court. Whether it is a Supreme Court, whether it's a High Court, whether a trial court, whatever is the content in your plaint, it is published. And if it is defamatory, defamation is done. That is also taken care of by the law. Order 6 Rule 16 specifically provides for striking out pleadings. If you don't plead properly, if you exceed your limits, if you abuse the provision of law, Court is not without power. But only thing is the opposite party should request the court to exercise the power and strike it out. In what cases? The court may, at any stage of the proceedings, order to be struck out or amended any matter in any pleading. In what cases? Which may be unnecessary, scandalous, frivolous, or vexatious. So it presupposes the pleading contains all these things. That's precisely what I am saying. Which may tend to prejudice, embarrass, or delay the fair trial of the suit. It is bound to come in the way of fair trial of the suit, which is otherwise an abuse of the process of the court. So in 1908, when CPC was drafted, I'm sure they had the experience. This is a platform which was abused even in those days. And if such an abuse is there, it was coming in the way of doing justice, speedy justice. And therefore, power was conferred on the court to strike out, remove everything. Today, this provision finds a place in the CPC amendment of 2015 insofar as commercial courts are concerned. Anyway, we are not going into that, but it's a different field. So we have taken so much time to repeat this. This striking out, not only you hear pleading, they are striking out in your affidavit itself, evidence in examination chief. So therefore, it presupposes that the pleadings contain unnecessary matters, scandalous matters, frivolous matters, vexatious matters, and it is done with the intention of embracing and no other purpose. That is not the issue involved in the suit. And because you are coming to court and sometimes lesser the court fee, more problem is this. You abuse the process and you make defamatory statements, get it published, ruin people. This is not the object of legal proceedings, a suit. And people when abused, yes, they should be shown their place. So as I said, that's why in the beginning I said, this legal profession is a noble profession. Lawyer is an officer of the court. He is a friend of the court. Dispensation of justice is a divine dispensation. You are an equal partner. If all this is correct, please see how you should conduct yourself when you draft a claim. If you are an officer of the court, that should be responsible. If you want speedy justice, your pleading should be precise. And you should not indulge in all these things, which is shows that a lawyer is a gentleman. Please understand, nobody is called a lawyer is a gentleman. If you indulge in this, you are not a gentleman. If you want to call yourself a gentleman, please follow the law. Please respect the law. Now, the law also provides there are limitations on the lawyers, limitations on the parties. They may come to court. On the day they came to court, they did not have full particulars. They get some information. It's very useful for determining the real controversy between the parties. Therefore, they should not be shut off. Therefore, Order 6 through 17 provides for amendment of pleadings. Order 6 through 6 said, if you want to depart, it should be by way of an amendment. Order 6 through 17 says, yes, you can file an application of amendment. This provision was the subject matter of big discussion for 3 years. Why? This is the most abused provision in the Civil Procedure Code. There is no litigation, no suit without an amendment application reaches its finality. What is the object? The object is to put forth the case. Most of the time, the object was to delay. This provision said the court may, at any stage of the proceedings, this at any stage of the proceedings has been interpreted to say not only the trial court, the appellate court, the high court, and even the Supreme Court. Anytime, allow either party, amendment to the written statement or to the plaintiff to alter, please read the alter or amend his pleadings in such manner and on such terms as to be just. And all such amendments shall be made as may be necessary for the purpose of determining the real questions in controversy between the parties. The way this provision is interpreted for more than 100 years is, if it is an application amendment, if what is pleaded is required for determining the case, court had the ample opportunity to allow them. As a rule, allow the amendment application. Whether the plaintiff or the defendant wins or lose is a secondary. At least let them have the satisfaction of saying whatever they want to say in the court. and court will decide the right. So as a rule, this amendment was allowed. And therefore, this provision was abused and it was coming in the way of progress of a case. Therefore, in 1999 amendment, they deleted this. Then the lawyers opened their eyes. There was a big jata in Delhi, tear gas. Lawyers were arrested. Why did the lawyers fight for this? You are not deleting it, you are a lawyer. It happened. Then the government of the day yielded. Then in 2002, they restored this order 6 to 17 and they added a proviso. What is the proviso? Provided that no application of amendment shall be allowed after the trial has commenced unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial. So some via media. All right, we will retain it. Whatever amendment you want to do it before trial. So as a rule, we will allow it. If it is after trial, as a rule, we will dismiss it. Still, some discretion is given to the court. If the court feels, in spite of due diligence, he could not do it, the court could permit it. So therefore, today, as it stands today, the amendment application before trial, allowed as a matter of course. After commencement of the trial, dismissed as a matter of course. But a discretion is given to the court because ultimately court has to do justice and then that power is conferred. So this is how the law specifically says how the pleading is to be done. So my grievance is, if the lawyers have respect for the law, don't worry about what others do. Don't compete with others. You're a lawyer, you're a gentleman, you want to reach the top, you want to advise your clients, you're a respectable man, you're a friend of the court, officer of the court. The minimum that is expected of you is to stick to this. So he is doing it. Hey, sometimes the argument is, I may do it, the judge may not understand, something may happen. Don't make your life dependent on others. Be confident. You make your life dependent on yourself. If you go on making your life dependent on so many people, then there is no life at all. If a lawyer were to say, this is not there, that is not there, for example, that's the apprehension. As a lawyer, as a learned man, you have got the courage to tell the judge on his face, this is the law and what you are saying is contrary to law. You should enlighten the judge. Of course, today the tendency of the lawyers is, in the past, nobody took it personally. Today they will take it personally. In their lifetime, they will not allow anything to happen. This is a professional risk we have to take. There are good judges, bad judges. Therefore, you can't change according to them. You be strictly in accordance with law. Tell the judge what the law is. Try to make the judge follow the law. And sometimes some percentage of judges will not be there. Don't worry about it. It's all part of the game. You must proud be out of it. You are an advocate. Knowledge is power. And when you exercise that power supported by sound knowledge, I am sure majority of the judges, they are gentlemen. They are also gentlemen. They understand. Only thing is, say it in a polite way. Don't bounce on them. Don't use aggressive words. Be polite. Tell them. If they are young, you tell them, you are yet to have some experience. I am a little more experienced than you. This is what I have found. If there's a judgment supporting it, give it to them. Even otherwise, show the provision of law. Tell the facts of the case and ask them to be within the four corners of law. You cannot go on drafting depending upon the lawyer, depending upon the opposite side, depending upon some judgment. Please don't do that. That is the root cause for all the problems today. And in the end of the day, justice is suffering. So therefore, when the law specifically says how a plaint is to be drafted, how a written statement, what are the limits, where you can expand, where you have to reduce, where you can strike off, where you can amend, where you can depart, your drafting should be. That is called art. If you are able to put it into practice, the principles underlying these pleadings, the way it is expressed in civil procedure court, it is a gem of a drafting and people will appreciate it, follow it. If somebody who doesn't understand this says something, why are you bothered about it? Your life is not dependent on that. Now, once these aspects are mastered by the lawyer, then you are expected to draft a plaint. That's the stage where before drafting the plaint, you must have all this in mind. Now, that plaint, law has not taken any chance. What the plaint should contain is also specifically stated in the plaint, in the CPC. Order 7, Rule 1 specifically says, what are the particulars to be contained in the plaint? The plaint shall contain the following particulars. What? 1. The name of the court in which the suit is brought, heading. The name, description, and place of the residence of the plaintiff. The name, description, and place of the residence of the defendant, so far as they can be ascertained. And where the plaintiff is or a defendant is a minor or a person of unsound mind, a statement to that effect, and application made for appointment of guardians. Then comes the cause of action column. That's the most important case. How a cause of action has arisen in the suit, because depending on the cause of action, you will decide in which court it is to be filed. Then facts constituting the cause of action. Cause of action, facts constituting the cause of action. That's where your ability is tested. How much you have to state. You must state so much. If read as a whole, it discloses as a cause of action. If it does not disclose a cause of action, plain will be rejected. So that's where I said it is a noun. Facts constituting the cause of action. And when it arose, your limitation has to be calculated. Then you have to say, courts have jurisdiction. The subject matter suit is situated within your jurisdiction. This is the value. So that you have to say it in the plaint itself and the relief to which you are entitled. When you look into the written statement, it provides a defendant can plead, set off. He can give up some claims. So if that is done, then it also can be set off. Then yesterday I was telling you the statement of the value of the subject matter of the suit for the purpose of jurisdiction and court fees so far as the case appears. Because there's a question of jurisdiction where you have to file a suit, those things have to be sued. In money suits, they have said how the pleading should be. That is precisely you say what is the amount due, and it should be in both words and letters, and there should not be any confusion. In the plaint at 3 places, you will give 3 figures, then there's a confusion. You must see that the amount you are claiming, the way you have set it out, and in the prayer column is only one and the same. If you are claiming interest, there's a law on interest. Interest prior to the date of the suit, from the date of the suit to the date of the decree, from the date of the decree till realization. How are you entitled to interest? Is it on basis of contract? Is it on law, trade, usage, rate at which the contract, the interest is claimed? All that should find a place in the plaint. And if the subject matter of the suit is an immovable, normally you give a small description in the plaint, and in the end you say, if this is more particularly described in the schedule here and there and hereinafter referred to as the schedule property. In the schedule, give a full description. Name, address, boundaries, measurements, whatever. So if it's a case of immovable property, it should be completely described in a schedule. That will be solve the problem. And if you are filing a suit in a representative capacity, that also should be mentioned. Then limitation. Suit should be within limitation. Section 3 of the Limitation Act says if it is not within time, even if the defendant doesn't take up the defense suit, the court has no jurisdiction. Dispute the suit. If the suit is in time, no problem. If the suit is not in time and can bring it within the exceptions in the Section 14 or other provisions, you must say so that this facts save the limitation. But as for the relief is concerned, you must be specific about the relief, because after all you have come to court, you should be clear about what you want. Of course, in the end of the day, we will say, such as the relief as a relief the court may grant. That should not be the first attempt. You ask for some relief. And as I pointed out to you yesterday, if you seek for some relief, relief is not granted, that means it is refused. Either you prefer an appeal or keep quiet. Otherwise, it operates as an adjudicator. So therefore, the law specifically says how a plaint is to be drafted. I cannot think of a better law than this. Absolutely no difficulty. If you are humble, simple English, if you want to follow the law, you can draft a plaint. Now, there was a big problem earlier. These pleadings are filed. Only suit document was produced. Other documents could be produced at a later stage. And there was no end to this production of documents. Therefore, in that 99 amendment, these provisions relating production of document was dispensed with, repeat, and they added what is called as Rule 14. This is very important. Please bear in mind there's an object behind this. Now what they say is, all the documents on which you rely on, whether it's suit document or other documents, you must produce it along with the plaintiff. So that time spent in collecting documents should go. Where a plaintiff sues upon a document or relies upon document in his possession or power in support of his client, he shall enter such documents in a list and shall produce it in court when the plaintiff is presented by him, and shall at the same time deliver the document and a copy thereof to be filed with the plaintiff. So therefore, this is a provision which is brought about with the intention of having speedy disposal of cases. If you don't do it, what happens? If the document is in the possession of the other side, where any such document is not in the possession or power of the plaintiff, he shall, wherever possible, state it in whose possession or power it is. Then a document which ought to be produced in court by the plaintiff, when the plaintiff is presented, which is called as a suit document, or to be entered in the list to be added or annexed in the plaintiff, but is not produced or entered accordingly, shall not, without the leave of the court, be received in evidence on his behalf at the hearing of the suit. But the thing is, rule shall apply to document produced with the cross-examination of plaintiff's witnesses or handed over to the witness merely to reference. I want the lawyers to understand the importance of this. See, filing a case is like getting ready for a battlefield. You can't say, I'll file something, afterwards we'll have some time, I will go on this. This is a careless approach. That's why I call it want of professional approach. When you are preparing a plan, collect all the information, collect all the documents, as far as possible, comprehensively draft a plan, make a list of all the documents, produce along with the plan. So much time is saved. If you want speedy disposal, do it. If you don't want speedy disposal, yes, the way it is practiced today is the best. At any rate, you cannot CPC for all these things. So therefore, today, the present generation, youngsters, please bear in mind, if you want to reach the top, there is no other way. If you indulge in all these sidetracks, you will be lost in the profession. If you want to reach the top, if you want to command the respect of the public at large and the litigant public, your drafting should be a piece of art, and that is possible only when you follow the principles of as stated in CPC. It is not your Shakespearean knowledge, it is not international commentaries which will help you in drafting your play. Knowledge is different. What you have to put it into court is totally different, and it should be in a manner understandable to the other side, to the court, so that you get justice immediately. This is about the plaintiff. Now, we have a written statement, a wonderful jurisprudence at development. I have seen a plaintiff is 40 pages. What is the written statement? The allegations in paragraph 1 of the plaint, take the entire is false. So 40 pages false. Then the case of the defendant is another 40 pages. Is it in accordance with the written statement as provided in civil procedure? I don't know. Somehow this, as days advance, this is increasing. And I'm sure that first denial is by the stenographer. You have not done it. A stenographer is a very experienced man. He will teach you. And all wrong things are taught by them because they have not CPC. They are experienced in this. And in youngsters, they will mislead you. Please, the time that you discard all these things. Please see what the loss is. And this filing of a written statement is a big matter in the earlier days. It used to take 2 years, 3 years, 4 years. That was the main reason. Getting the defendant served was a big problem. After he served, I told you an application calling for particulars, that will take 1.5 years. And then time for written statement. For 3 years, 4 years to file a statement. And where is the speedy disposal? Therefore, in 2002, law is amended. There is an object. The defendant shall, within 30 days from the date of service of summons on him, present a written statement of the defense. It was not there. Earlier, there was no time limit. Now, a time limit is 30 days. And then there's a proviso. If for any reason you are not able to do it, you have to do it in another 60 days. And we also interpreted this provision, and I am also guilty of that. We said it is not mandatory, it is directory, court power cannot be taken away, and therefore time was extended. Today, I am sure in nowhere, no written statement is filed within 30 days. The very object of the amendment is lost. See, if you are a professional, you don't need 30 days time to, if you are not a professional, then you need time. All right, if you want some time, 60 days should be the time. When you people are talking about speedy disposal, when you say I am impatient, I want disposal, first you must start doing it. Time limits are prescribed. Discretion was given to the court, they abused it. Discretion was given to the lawyers, they abused it. Now the law has stepped in and say you people should do things within this time. Even then you don't. I only say you have no respect for the law. Without having respect for the law, how can you expect to be a lawyer and get on with the profession? Then they also said, added 1A, as the plaintiff, you also produce all documents on which you rely on along with the written statement. Don't go on asking for time. Why? Speedy disposal. Then, elaborately, as in the plain, they have also said how a written statement, because it's a very powerful weapon. If you are pleading new facts, if the plaintiff has so many facts, either you admit or deny, that's the end of the matter. If you are pleading new facts, Order 8 Rule 2 says, new facts must be specifically pleaded. The defendant must raise by his pleading all matters which show the suit not to be maintainable. Standard practice is, I think today there is computer, otherwise even without a computer, how the written statement is common. The suit is not maintainable, the court has no pecuniary jurisdiction, the court has no territorial jurisdiction, suit is barred by res judicata. Standard defenses. CPC says the defendant must raise by his pleading all matters which show the suit is not maintainable or that the transaction is either void or voidable in point of law, and all such grounds of defense as, if not raised, would be likely to take the opposite party by surprise or would raise issues of fact not arising out of the plaint, as for instance, fraud, limitation, release, payment, performance, or fact showing it. Whatever you also should plead. The plaintiff should know what your defense is. Court should know what your defense is. So specifically do it. Having said that, specifically you must prove your case. Further, the CPC says, plaintiff has pleaded something, is it not so? You have to say. They say, the first rule, if you are denying something, the plaintiff has pleaded, the denial should be specific. Order 8 Rule 3. It shall not be sufficient for a defendant in a statement to deny generally the grounds alleged by the plaintiff, but the defendant must deal specifically with each allegation of fact of which he does not admit the truth and accept them. The defendant hereby denies all the allegations made in para 3 of the plaint, and the plaintiff is put to strict proof the same. It is not denied. Now, 2015 amendment says if you are denying it, you have to give reason why you are denying it. I am not going to that because that's a different area. Even without that, Order 8 Rule 3 says if you are denying a particular fact, you must deny it specifically. General denial is no denial. In general denial means there is no denial. Having said general denial to be specific, then they have said evasive denial I will not accept. Denial should be specific. If it is evasive, it is an admission. Where a defendant denies an allegation of fact in the plaint, he must not do so evasively, but answer the point of substance. Thus, if it is alleged that he received a certain sum of money, it shall not be sufficient to deny that he received that particular amount, but he must deny that he received the such amount or any part thereof, or else set out how much he received. And if an allegation is made with diverse circumstances, it shall not be sufficient to deny it along with those circumstances. Denial should be specific. Denial should not be evasive. And further, what do you mean by a specific denial? And what is the consequence of not denying? Denial should be specific. It should not be evasive. And if you do not do this, the consequence is set out in Order 8 Rule 5. Every allegation of fact in the plaint, if not denied specifically or by necessary implication or stated to be not admitted in the pleading of the defendant, shall be taken to be admitted except as against a person with a disability. It has the effect of an admission, provided that the court may in discretion require any fact so admitted to be proved otherwise than by such admission. Provided that every allegation of fact in the plaintiff not denied in the manner provided in Rule 3A of this order shall be taken to be admitted except against a person under disability. In fact, that is for commercial courts. So law specifically says denial should be specific, evasive denial is not accepted. If the denial is not in the manner stated, it amounts to a denial. So therefore, what more do you want? Law says how you have to draft a written statement, how you have to draft a claim. Now, when you deny in a money claim, what are the defenses which are available to you? You can say, I have not borrowed the money. Or, yes, I have borrowed the money, I have repaid it, free of discharge. Or, yes, I owe you that money, you also owe such money, set off. And you can also put forth the counter. For all that it is provided for. If it is a case of set off to be given in the written statement, the law says, when a suit for recovery of money, the defendant claims to set off against the plaintiff's demand any ascertained sum of money legally recoverable by him from the plaintiff, not exceeding the pecuniary limits of the judge of the court, and both the parties fill the same character as they fill in the plaintiff's suit, the defendant may, at the first hearing of the suit, but not afterwards, unless permitted by the court, present a written statement containing the particulars of the debt sought to be set off. So you have to specifically say what is the amount, what is the debt due from the plaintiff to the defendant, and you must seek set off. Now the question is, what is the effect of set off? The written statement shall have the same effect as applied in a cross suit, so as to enable the court to pronounce a final judgment in respect of both the original claim and the set off, but this shall not affect the lien upon the amount decreed of any pleader in respect to the cost payable to him under the deed. In the case of a set off, it is a monetary claim. Plaintiff has a claim, defendant has a claim, and both will be considered. And if the defendant says, set off the amounts due to me from the plaintiff toward the money due to the plaintiff, the court will pass one decree. This is set off. Always the set off is only in respect of money. Law also provides for what is known as counterclaim. Please understand the difference. Discharge, I have paid the money. Set off, yes, I owe you, you owe me, set off one against the other. Then third is counterclaim. I may not be liable. You are liable to me. You pay me the money. That is the counterclaim. So now that counterclaim is also substantially amended in the recent amendments, and meticulously it is provided for. It provides for a counterclaim by the defendant. Here, the counterclaim may be different, a money claim, and the counterclaim may not be a money claim. It may be a money claim or a totally a different claim. A defendant in a suit may, in addition to his right of pleading a set off under Rule 6, set up by way of counterclaim against the claim of the plaintiff, any right or claim in respect of a cause of action accruing to the defendant against the plaintiff, either before or after the filing of the suit, but before the defendant had delivered his defense or before the time limited for delivering his defense is expired, whether such counterclaim is in the nature of a claim for damages or not. This has been the subject matter of interpretation. That is, please see the verse. Accruing to the defendant against the plaintiff, either before the cause of action for the counterclaim might have arisen before filing of the suit. It may also accrue after the filing of the suit, because we have some judgments, they have disputed it. Even after the suit is filed, cause of action for a counterclaim arises, defendant is at liberty to put forth that counterclaim in the written statement. Sometimes it so happens in the written statement it does not put forth the counterclaim. Has he lost his way? No. Before the defendant has delivered his defense, that is written statement, or before the time limited for delivering his defense is expired, whether such counterclaim is in the nature of claim for damages or not. So therefore, this counterclaim is in the nature of a counter suit. When it is in the nature of a counter suit, all the rules which are applicable to the plaintiff applies to the counter suit, counter claim. The difference between set off and counter claim is set off always should be in form of money, whereas counter claim may be in form of money or any other right. But one condition is such counter claim shall not exceed the pecuniary limits of the jurisdiction of the court. Then they have made it very clear, such a counter claim shall have the same effect as a cross suit, so as to enable the court to pronounce a final judgment in the same suit, both on the original claim and on the counter claim. When there is a counter claim, there will be two decrees. In the case of a set off, one is set off against the other, only one decree. In the case of a counter claim, a decree for the plaintiff, a decree for the defendant. There is no question of setting off one against the other. Then once this counter claim is put forward, when it is a cross suit, the plaintiff shall be at liberty to file a written statement in answer to the counter claim of the defendant within such period as may be fixed by the court. So he has a right to file the written statement. And then the counter claim should be treated as a plain and governed by the rules applicable to plaintiffs. That's a cross suit. Then 6b says counterclaim to be stated. 6c says exclusion of counterclaim. The court feels, no, you please find it out. The court has the power to throw it away. And when a counterclaim is there, the plaintiff does not press the suit. It is dismissed for default. The counterclaim doesn't get dismissed automatically. The court is bound to hear the counterclaim because a cross suit. Plaintiff may not be interested in the suit. Though it is a counterclaim filed in the suit, the dismissal suit for default will not prevent the defendant from prosecuting his counterclaim, and the court is bound to conduct a trial and decide the counterclaim on merits. Similarly, if the plaintiff fails to file a reply to the counterclaim, that means he is not disputing the claim. So therefore, everything is meticulously set out in the plain. Unfortunately, lawyers, more they are intelligent, they ignore the CPC and they start their own practice. And in every district, they have their own practice. In North Karnataka, one practice, in Bangalore, one practice, in Bangalore, one practice. Then why do you need a civil procedure court? But all of you join hands in blaming the CPC. You follow the CPC, you follow meticulously what they have said. Let us see why there won't be any speedy disposal of cases. If the parties wants it, if the lawyer wants it, I'm sure you will have the speedy disposal. And if the judge doesn't cooperate, teach him, tell him, assert your right and have a disposal. So therefore, Civil Procedure Code is a wonderful piece of legislation. It has to be understood and respected and followed. I don't think there is any difficulty in following the Civil Procedure Code. And you can have your own procedure. And if every lawyer has his own procedure, if every court has his own procedure, then be total chaos. That is what has happened today. Please don't blame CPC. Now, once the pleadings are complete, as I said, there are admissions, there are denials, there are counterclaims, there are specific defenses taken by the defendants. The court has to frame issues. What do you mean by an issue? Issue means a point in question at the conclusion of the pleading between the contending parties in an action. People have not given sufficient thought and seriousness to this framing of issues. Framing of issues is an important stage at which the scope of the trial is determined. The duty of the raising of the issue rests in the Civil Procedure Code, in the Civil Code, and I would say a duty is cast on the lawyers also to assist the court in framing issues. That's why they say, please file draft issue. Even if the draft issue is filed, the judge has to apply his mind and then see proper issues are framed. If the judge has not framed proper issues, then a duty is cast on the lawyer to say, you frame a proper issues. Unfortunately, in real practice, this is not done. It is something the lawyer thinks it is the opposite, and the judge will simply take some draft issue and adopts it. This is not the way a civil suit has to go on. So therefore, please be clear in your mind. When we talk about Framing of issue is a very, very, very important stage in a civil proceedings. Now, rule 1, please read it so carefully, they have made it. Issues arise. How does an issue arise? Issue arises when a material proposition of fact, plain should contain material proposition of fact, material facts. So issue arises when a material proposition of fact or law is affirmed by one party and denied by the other. In the admission, there is no issue, there is no dispute. Then what do you mean by a material proposition? What do you mean by material facts? Material propositions are those propositions of law or fact which a plaintiff must allege in order to show a right to sue, or a defendant must allege in order to constitute his defense. That is the substance, crux of the problem. Each material proposition affirmed by one party and denied by the other shall form the subject matter of a distinct issue. Please see this word, distinct issue. I will tell my judges, you frame 10 issues. Why did you do it? Law said frame distinct issue. After framing 10 issues, when writing a judgment, you cannot say the evidence is overlapping, I will decide all one issue. It is the judicial dishonesty. When a distinct issue is there, you must answer them distinctively. Maybe 1 or 2 issues, they may be overlapping. You can't say I will answer all the issues. That's not the way to do. Now, when we are talking about, there are 2 types of issues. One is issues of fact and another is issues of law. Now, by practice, we have said there is a mixed question of law and fact. Limitation is a mixed question of law and fact. Res judicata is a mixed question of law and fact. CPC doesn't say. It is, we have said it and it has now fairly accepted. CPC recognizes only 2 types of issues, issues of law and issues of fact. Now, please see how meticulously the CPC is worded. Before framing the issues, what is that a judge is expected to do? What is that a lawyer is expected to do? At the first hearing of the suit, the court shall, after reading the plain and the written statements, if any, and after examination under Rule 2 of Order 10, and after hearing the parties of the pleaders, ascertain upon what material propositions of fact of law the parties are at variance, and shall thereupon proceed to frame and record the issues on which the right decision of the case appears to depend. Please tell me whether any lawyer, after filing the framing of issues, appears before the court and tell them this is the case of the plaintiff, this is the case of the defendant, this is the issue to be raised, please frame the issues. But when the issue is not framed, you blame the judge. Most of the time, the judge is very young, lawyers are experienced, and you don't assist. You are a friend of the court, part of the administration of justice. Law says hearing the parties of the pleaders, you owe a duty to tell the court what proper issues are to be framed, what is the crux of the matter, what is that they expect from the judge in this case. Nothing in this rule requires the court to frame and record issues where the defendant in the first hearing of the suit makes no defense. When there is no defense, there is no issues. Then we have what is called as burden of proof under the Evidence Act. And then, this is important, Order 14 Rule 2 says, court to pronounce judgment on all issues. That's the rule. When you frame 5 issues, you must decide all 5 issues. Notwithstanding that a case may be disposed of on preliminary issue, the court shall, subject to the provisions of the Rule 2, pronounce judgment on all issues. As a rule, you should decide all issues. Exception is found in Sub-Rule 2, where issues both of law and fact arise in the same suit, and the court is of opinion that the case or any part thereof may be disposed of on an issue of law only. In issue of law, there are 2 types. Issue of law only. It may try that issue, that is issue of law, first, if that issue relates to the jurisdiction of the court, a bar to the suit created by any law for the time being. It is an issue of law, but that issue of law should touch upon the jurisdiction, touch upon the bar. Then that issue is to be tried as a preliminary issue. Otherwise, no. So this is the purport of, in fact, the amendment brought about in 76. Now, from what material you have to frame issues? I read it plain. Again, it is asserted the court may frame the issues from all or any of the following materials. What? Allegations made on oath by the parties, or by any person present on their behalf or made by the pleaders of such party. This refers to Order 10, Rule 1, first hearing. Allegations made in the pleadings or in answers to the interrogatories delivered in the suit. 3, the contents of documents by either party. You have to look into all this. Virtually, the court has to look into all this before framing issues, and the lawyers owe a duty to assist the court. Otherwise, proper issues are not framed. In fact, the law provides examination of witnesses to understand the case even before framing issues. That is the importance the law is given. And then, with all these issues are framed, unwanted, frivolous, which does not arise, and you don't raise issues which arise. Then what is to be done? Order 14, Rule 5 specifically says, the court may, at any time before passing a decree, amend the issues or frame additional issues on such terms as it thinks fit, and all such amendments and additional issues are necessary for determining the matters in controversy between the party shall be so made or framed. That is, amend the issue, probably burden of proof is not placed properly, amend it. An issue has not been framed, frame an additional issue. Suppose you have framed an issue which doesn't arise for consideration, then court may also, at any time before passing a decree, strike out any issues that appear it to be wrongly framed or interpreted. Absolute powers are given. Why? The trial should be proper. It should be concentrating on real points, and you should not miss the point. If this is done, this is the battlefield. You said pleadings are complete, proper issues are framed, now the battle should start. So that everybody has full opportunity, understood the case, now they know what evidence is to be adduced and what case of the opposite party is to be demolished, what case of theirs is to be established, what is the evidence they have, documentary evidence, moral evidence, presumptions, judgments. You are ready. That is what is expected. If you do it, no suit will drag on in courts for years, Anyway, thank you.
Thank you, sir, for enlightening us and sharing your valuable inputs. Now, moving on to the question and answer session. The first question is as follows. Sir, if once the issues are framed, whether court can decide on cause of action based on the application filed under Order 7, Rule 11A in a partition suit?
Order 7, Rule 11 says, if the plaintiff does not disclose cause of action, plaintiff is to be rejected. Assuming issues are framed. If they are properly framed, that it means there is a cause of action. Suppose if the issue is not properly framed, the person who wants the plaintiff to be rejected should show there is no cause of action. The issue you have framed does not arise for consideration. You have done it on some imaginary grounds, and therefore rejected. Therefore, rejection of a plaintiff on the ground it does not disclose the cause of action is totally different from framing of an issue. That's why I said an issue which does not arise, an issue may be framed. Issue is not properly framed, and a proper issue is not framed. That's why the court has the power to do all that.
Thank you, sir. And the next statement is, pleading should contain evidence and vice versa. Please explain, sir.
Pleading should not contain evidence, not pleading should contain. Pleading should not contain evidence. Evidence should be adduced after the issues are framed and the case is posted for trial. If you plead evidence, it's a bad draft. Plain and written statement should contain only pleas. At the time of trial, you should lead evidence to prove that pleas. Law says it should not contain evidence. Today, unfortunately, it contains evidence.
Thank you, sir. And next statement is, pleading should be precise, but should have all details. Are they not contradictory?
Certainly not. When we say pleading should be precise, particulars of the plea should be stated. But you are saying the particulars, as I said, you go on saying history, geography, that is no, it is nothing to do with the pleading. Suppose you say plaintiff is the owner of the property. What are the particulars? Plaintiff purchased this property from the previous owner and the registered sale deed dated so and so. After purchase, he got the kata transferred, he is paying taxes, he is in possession, he is the absolute owner. This is the particulars which is required in a suit for declaration of title. If you say Kempegowda constructed Bangalore in so and so years, then in so and so year a layout was formed. In that layout, so and so was purchased the site. From there, it has came. That is history. You confine it to your case. From how you got it or how he got it, that is something. Don't give the history of Bangalore, don't give the history of India, and don't quote other things.
Yes, sir. Thank you, sir. And the next question is, in a suit for partition, whether the plaintiff can file an application for amendment to delete a scheduled property for the reason being litigation is settled between the parties?
Nobody can prevent an application being filed, but the courts will not entertain it. They will dismiss it. Everybody is freedom.
Sir, if you...
Fundamental right to file applications.
Yes, sir. Thank you, sir. And if you could permit, can we take 2 more questions, sir?
Yes. Yes.
Yes, sir. When you deny the allegation in the written statement, should we not tell the background story when we are denying, or simple denial will suffice?
Story, no. Facts, correct. Now, in the amendment of 2015, if it is a commercial contract, mere denial is not sufficient. They say you must give why you are denying it. When you say why you are denying it, it's only the facts leading to the denial. Again, not the story. You should not tell stories. Plaint is not a storytelling. It's facts, true facts. But unfortunately, we say stories, and it is not possible to prove stories. And you make an attempt to stories. That's how time is consumed. And that's how sometimes the entire proceedings get derailed. No storytelling. Particulars, yes.
Next question, sir. What is the meaning of pro forma defendant and pocket defendant?
Pro forma defendant.
Yes, sir.
See, there is what is called as necessary party and a proper party. Sometimes you don't seek any relief. You make them party. Take, for example, I have filed a suit for declaration of title against the defendant who is denying my title. Sometimes I make my vendor is also a party to tell the court, look, I got the property from him. I am not seeking any relief. So they are all pro forma parties.
Yes, sir. Got it, sir. And sir, one last question for the day. In a suit for injunction, whether defendant can file counterclaim of declaration?
Why not? Sure. Because discretion is given to the court. If the court says, no, you have a separate suit, yes. But there is no prohibition in law. In a suit for bare injunction filed with the plaintiff, defendant can file a suit for declaration in respect to the very same property. It can be filed.
Yes, sir. Thank you, sir, for answering all the questions. I would like to extend my cordial thanks to all the participants. And a motivator says that result is a one-time process, effort is a continuous process, and learning is a never-ending process. So keep on learning and keep on supporting. Sir will elucidate on the topic return of plaint and rejection of plaint on 9th November 2020. Now I take up this opportunity to extend gratitude to our eminent speaker, Hon'ble Justice N.Kumar, retired Judge of High Court of Karnataka, Shri Gautam Chand SF, President of KSBC Law Academy, Shri Anil Kumar JM, Chairman of KSBC Law Academy, all the members of KSBC Law Academy, hosting committee members, and all the participants who are eagerly taking part in the webinar series. Have a joyful weekend. Thank you all. Thank you, sir.
Thank you.